Good afternoon and hello, HR GovCon friends. Welcome to the 19th episode of the GovCon HR Round-Up Podcast. We hope everybody out there is enjoying the remaining days of our summer here. It's harder to believe that it's August already. Special welcome to any first-time listeners that are joining us today, and obviously welcome back to our growing legion of loyal listeners. Legion may be a little aggressive. I'm not sure what the sure what the exact definition of legion is, but I like that word.
We'll take it.
Okay, we're going to go with legion, our legion of loyal listeners. So
throngs.
Yes. So welcome back and good afternoon, everyone. Thank you for taking time to join us. My name is Joe Young. I am the president of GovConPay. We are the only outsourced payroll and HR service provider dedicated exclusively to serving the government contracting marketplace. We are joining you live from the Tyson's Corner studios of BLC Digital Strategies, the media affiliate of Berenzweig Leonard LLP, with the support of both of our teams, and in particular, our producer, Mr. Todd Castleberry. Before we jump in, we always want to take time and recognize our sponsor, the great folks at Berkshire Associates. For those of you who are not aware, Berkshire are an HR compliance experts with over 50 years of experience in providing compliance services and technology for organizations looking to build their ideal workforce through compliant, non-discrimination services, workforce analytics, and pay equity expertise.
And they have been busy.
They have been very busy, and we'll get into our topic again today. That kind of aligns with our sponsor again, but definitely welcome to any Berkshire clients who are joining us today. Great to be back with my colleagues here on the Roundup. So managing partners of Berenzweig and Leonard, Seth Berenzweig, Declan Leonard. Guys, why don't you introduce yourself to any of our first-time listeners?
Yeah, no, it's great to be back. I actually missed at least one of these. I forget. I think I was on travel maybe last month. So, but my colleague Nick Johnson probably more than filled in for my shoes here.
He has his fans in front of the building right now.
Yes.
Boy, are they going to be disappointed seeing me. They're going to throw subs at me when I go out there or something like that. That seems to be the way to do it. So I'm Declan Leonard. I am managing partner here at Berenzweig Leonard, and I head up the firm's employment law practice.
And I'm Seth Berenzweig, co-managing partner here at the firm, and I help head up our corporate and transactional practice. And we're not throwing any Subway sandwiches on the show today.
I think I missed something in the news on Subway sandwiches.
Oh, you need to look this up. It's actually somebody he actually worked for the Department of Justice. I know we're off topic, but he was not happy with the show of force in D.C. with National Guard and stuff. So he went up and attacked one of them with a Subway sub. Lost his job, but now he's an icon, and they have murals all around D.C. with this guy throwing a Subway sub.
And someone put out a clip with the background music, "Looking for a Hero." And I don't know if they were referring to
I have no idea how I've missed this, but I will definitely first thing of you after the show today. All right, well, the show today and our topic, I'm going to share was a little debate for the first time, a little maybe I want to say controversial.
We got pushback here.
What's our topic going to be? As we've been trying to be timely and not putting out topics, and we got together a few weeks ago. And Seth and Declan are like, well, there's this new news in DEI. And I'm like, DEI again? Like, how much can we talk about DEI? But I have to listen to the voice of counsel here. So kind of almost in fun, like the title of our topic today is, why are we still talking about DEI and why you still need to pay close attention? So for any of you who are like, oh my God, they're doing DEI again, and you're about to log off, stay. There is more breaking news on this topic, and we look forward to jumping into it today. So, with that as a lead-in, start with you, Declan. As I said, I feel like we've talked about this ad nauseum.
Exactly.
So
why are we needs the DIE?
Yeah. So why are we talking about this again in August?
Yeah. No, it's a good point. And I will say, as an employment lawyer, I deal with this stuff all the time, and I even am tempted to tune out when I hear this. It's like, okay, we get it already. DEI bad, But I think the reason why it's so important to talk about it, first off, the Department of Justice just issued a memorandum 2 weeks ago that we'll want to talk about today, because one of the things that one of the criticisms, I guess, of the administration's actions when it came to DEI is they would say DEI is bad, and if you engage in illegal DEI, you're going to lose your funding. You're going to lose contracts. You're just not going to be in business anymore. And then people would say back, well, okay, but what does that mean? So we have a little bit more clarity, and we're going to try to get as granular as we can today throughout this webinar on, what it is, what are things that this administration is going to look for. A lot has happened in the last, 6 months. And I think if I can be candid, a lot of people with this administration think, it's kind of like, hey, look, there's a squirrel. They do things, and then they move on to the next thing, Even DOJ is kind of an example. We kind of hope that, DOJ maybe is subsiding a bit for a lot of our contractor friends out there, and things will start to get a lot more robust in the contracting industry. But the reason why we're talking about it here today is because it is not a fad. It was not something that they just rolled out and said, we made our point, now let's move on. There are concrete actions that we're going to be talking about today, such as this memo and some other enforcement action, that shows that they are very serious about this. They are following through on this, and contractors have to pay attention.
So we're going to get into some of those specifics here, obviously, in our time this morning. But Seth, how worried should kind of the not that any of our people go run of the mill, but the run of the mill GovCon, for lack of better terms, how worried they should be that they'll be targeted?
So the news that I saw just this week, just a couple of days ago, where my first reaction was, this is kind of a big deal, is when, as a result of this new, more detailed memo out from DOJ, which Declan was talking about, came out. It came with an announcement that the Justice Department is now threatening to use a very powerful tool in its toolbox, and it's called a civil investigative demand, or sometimes known as a CID. And it is a letter from the government to the recipient noting that there is a fraud-related investigation underway, and that the company is required within a defined period of time to produce documents in reference to that. Now, the reason why this is a big deal is that even though it's called a civil investigative demand, I think that label's a little bit misleading, because this relates to allegations of fraud, potentially under statutes such as the False Claims Act. So this is kind of a big deal. This is really where we've turned a new corner when it comes to DEI, and Declan, I agree with you. This isn't like, when is the new squirrel coming out? The squirrel is still very much just kind of, right out on Front Street. And as a result of that, the companies that might be subject to some kind of a question or review, even if they've done nothing wrong, might be subject to this new heavy hammer that's being brought out to bear by the Justice Department.
And you're right that while these are called civil, it really is a misnomer, because, in essence, what it would require without any kind of a court proceeding or anything along those lines, you get this letter, and it is kind of a oh crap moment, because you're going to have to turn over a whole bunch of documents and records, and they're not telling you exactly what roadmap they're going on. It's like you're kind of like turning over a bunch of stuff blindly, and this stuff there's no immunity by turning it over. This stuff you could be very much providing the evidence that then results in some kind of bigger problem for the company.
Yeah, and unfortunately, much like a government subpoena, they tend to be usually a little bit overly broad. And one of the things that you may be able to do through your legal counsel is to try to argue and narrow the scope. The problem is that it's more specific and it's more target intensive from a fraud allegation perspective than a general third-party witness subpoena. So it creates its own unique dimensions and demands when these things are issued by the Justice Department.
So in the event one of our listeners is unfortunate enough to have one of these arrive in their mailbox, what's the immediate next steps they should be taking?
First off, take it very serious. Don't just be like, oh, what's going on now? Definitely take it very serious. I would suggest, and again, it's a self-serving plug, but I would suggest contact counsel immediately. And I say that for a couple of reasons. One is you want to make sure that everything you do, everything that you do and every action that you take and every communication internally is cloaked with the attorney-client privilege. If you all start talking amongst yourselves and company, let's say the CEO and the COO and the CFO are all having this group chat, that's all very much discoverable. So they really need to be careful, if they say things that are incriminating or create liability on the civil side. So very important to engage counsel and make sure you set up that attorney-client privilege so that you can shield those communications.
I'll give an example of that because I think that that's really important. Let's say that this comes in, and before engaging counsel, you send out an email to the C-suite and just say, look, we're going to have a meeting at 4:30 today, and we're going to talk about this. If you have any thoughts ahead of time, let me know, and then we'll send out a Zoom link. If the attorney for the company is not CC'd on that email, that is going to be discoverable. However, if you simply CC your attorney and keep him or her involved even tangentially in the loop, that can be included in a privilege log, and then that communication does not have to be produced to the government. So it's the devil's in the details, and you don't have to do a lot to get the attorney involved, but I agree that it's something that you really need to think about from step one.
Great.
Yeah.
One thing I forgot to mention at the beginning is if anybody has any questions, like always, feel free to put those in the chat. Our team will be monitoring those, and they'll put those up, and we'll try and address them while we're on here today. So just wanted to remind everybody about that. So Declan, I mean, you kind of mentioned earlier, I mean, part of the frustration is we were dealing with this, 2 days after inauguration, and then in the months leading was like, they were mentioning all the things at DEI, but there was kind of lack of definition. Well, what does this really mean? So that seems like that's changed.
Yeah,
I mean, there's more definition, more concrete.
Yeah, this memo, and the memo, by the way, they make it clear that the memo is non-binding. I don't know what that means because it's a memo from DOJ, so I would take it very seriously. And I think arguing that it's non-binding, it's only because procedurally they were able to issue it that way, and that's how they were able to do it. It does provide a little bit more specifics. I'm not going to, come in here today and say, here's an exhaustive list of all the things that they're going to be looking for. But definitely, the one thing we do know from this administration is that not all protected classes and not all discrimination is viewed the same way. This administration focuses mainly its target on race and gender actions that they believe are discriminatory. And so, you've got things like, training sessions. We've heard about these, and certainly during the Biden administration, they made some news where, people would have to go into employment training where they would talk about things like white privilege, toxic masculinity. We heard these phrases. Those, if you have training sessions now, those will be absolutely a target by this administration. Those are absolutely a no-go nowadays.
Zone. Yeah.
Yeah. These safe spaces. I mean, I think that this memo didn't just touch on employment. It talked about a couple of different things, including colleges, but any place that's like a safe space that caters to specific minority groups. Again, those are illegal DEI. Those could get you one of these civil CIDs. That could be the subject of a quitan action, which are all very disruptive and very costly. If you've got one of the examples they gave, Black Employee Support Network, if you have that within your company, that has to be disbanded, I mean, according to the administration in this memo. And also during the interview process, you hear about questions like your cultural background. If they delve into your cultural background, if they say, what are obstacles you have overcome? Now, those are your first generation status. Do you come from an underserved geography, when it comes to some of these jobs? Those are what this administration and the DOJ memo calls proxy for eliciting DEI. So in other words, you're not asking specifically, hey, how does your race help you in doing your work here? But instead, they believe that these are just sort of proxy ways to elicit illegal DEI.
And I would say also that those, even if you could view those as, let's just use the phrase soft offenses, right? To just say where the government can try to peer in. One of the problems that this strikes in my mind is the element of the former disgruntled employee. Because if you have someone out there who has an axe to grind, these kind of soft violations could really be fodder for them to file a complaint. And the government is more than happy to receive these kinds of complaints. So, I can imagine, HR directors listening to this right now just saying, oh, come on, give me a break, really? But yeah, I mean, that's the environment that we're operating in right now, and you just have to be aware of it, and your managers have to be aware of it as well.
Yeah, I didn't make these up. These are coming from the memo.
100%.
Yeah, these are coming from the memo. These are the things that they're watching out for.
Yeah.
And they want nothing more than to make a high-profile example.
Sure.
And you don't want to be that company.
Yeah.
So a couple questions that just came in that kind of speak almost specifically kind of like to this. Mm-hmm. So a company has an internship program that has a close connection. In this instance, it says Howard University. Consider it any maybe historically black college. Is that a problem under the current administration?
Yeah, I mean it's so. In a vacuum, I would say yes. But I think if they also have an internship program where they, for lack of a better phrase, fish from many ponds, like, they go out to Silicon Valley, they go to all different areas. But if they are specifically targeting HBCUs, that to me would be a problem. And that gets to obviously race, and race is a big target in this administration, race and gender.
That's a great point. So the answer as a practical standpoint isn't, oh, you have to get rid of it.
Yeah.
Perhaps one of the remedies is fish from a whole bunch of different kinds of ponds. One of the examples that we were reflecting on is whether, when you single out employees who are new moms in a company newsletter, what about new dads? Again, not to make too fine a point on it, but if you fish from many ponds, it doesn't mean that you can't fish from one in particular, as long as you're showing that you're not giving undue favoritism in that regard.
Yeah, I would not advise a client to disband that internship program.
Right.
I would just say you need to broaden the number of colleges and universities.
Diversity, yeah. I mean, you got to.
Don't say diversify.
Yeah.
It's too close to diversity.
I didn't say that. As I said it, I caught myself. I was like, well, that's probably not the right word to use.
We almost had a nice guy bust in here. Put your hands behind your back.
All right, so we're talking about obviously the administration. This is pressing as it relates to employees. What do we think is next as it relates, to GovCons and the 8A program? I mean, that obviously kind of becomes kind of the next step in the question.
This is the question that all government contractors in our area are asking themselves. Yeah,
this is the one that people know that they're thinking about, but that they don't want to talk about.
Nobody wants to talk about it.
Yeah, I mean, it doesn't take. There's always a crack in our crystal ball. We don't know exactly what's going to happen next, but you can see that gender and race preferences in the granting of contract awards within, for example, the 8A world is something that is probably somewhere in the back of Trump's mind. Now, and I think that those kinds of set-aside programs, the best way that I would describe it is that I would just place them on watch. Now, of course, people that are listening to this are saying, look, that's a different ballgame because a lot of these are statutorily prescribed.
Yeah. Well,
first of all, that doesn't mean that Congress can't get into the act. Second of all, I don't know if you've noticed, but Trump is not a very shy person. So he may do, at a minimum, issuing a directive for agencies to start to conduct an administrative review of whether or not to continue those programs. And by the way, some of those agencies have already started to do reviews and audits of 8A programs and awards. So this is something that I would describe as being on watch. This will not likely affect veterans and disabled because those are two categories that the administration does not similarly view. Mm-hmm. But what do you think, Declan?
Yeah, no, I do agree. There are ways, while the Trump administration, because this is congressionally codified, the 8A program, they can't just disband it, without congressional action. But there are ways to chip around it. I mean, they can direct contracting officers to use different vehicles so that they really erode it as opposed to eliminate it. And then they can also turn their sights on these companies and start to really scrutinize a lot more carefully. You say you're a women-owned small business. Okay, let's look at this. I mean,
Right.
how deeply involved is the women, especially in a spousal business ownership?
That's the way that they would go first.
Yeah.
That's the way that you would go first, because if a company, and I know that none of our clients are like this, but if there's a company out there that's taking some liberties, not giving respect to the idea that the person who is socially disadvantaged isn't running the day-to-day management, oversight, and operations of the company, that is the lowest hanging fruit, right?
Yeah.
Yeah.
So I think they'll chip away at it. And so I think that that's probably in the short run what's going to happen. But then they could galvanize support in Congress. I mean, he's been able to get his way. Let's put it that way. So it may be something that they take on.
Interesting. Yes, obviously a topic that everybody will be paying attention to if things start to head down that road. With all of these things, we talk a lot about, for the contractors' responsibilities, but there's always a situation of the prime contractors and what responsibilities they have for their subs. So, what's the scenarios now as primes that have subs and how they have to be not only looking at their own direct organization, but monitoring the activity and the policies of their subs to make sure that this doesn't flow up?
Yeah, this was an interesting component of the DOJ's memo because they specifically, it's one of those things where, it's hard enough to kind of police your own company. But now what they're basically saying for primes is, look, you also need to make sure that your subcontractors are not engaged in illegal DEI. And they specifically mentioned the phrase monitor, that the prime would serve as a monitor. So how you do that, I don't know. It's hard enough for some of these companies to even know exactly if there is any kind of illegal DEI in their own operations, let alone subcontractors. So it's going to be important for primes in their contracts to make sure that at least they say that you will not engage in any illegal DEI. They can reference as many documents, potentially even reference this DOJ memo, just to kind of CYA as best they can.
Put it in a teaming agreement.
Yeah.
Why not?
All of that stuff.
Why not?
It's going to have to be in there. And then, how they actually monitor it beyond that is going to be a different issue. And then, it's a double-edged sword because the more a prime tries to insert themselves into a subcontract's operations, then they run a risk of are you a joint employer at this point? So you always try as a prime to maintain some separateness with your subcontractor. So this is going to be a bit of a double-edged sword for primes. It puts them in a very, very tough situation.
Yeah. No, I agree. And I think that, it reminds me of the phrase, no good deed goes unpunished.
Yeah.
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 So to wrap this up, I guess here, Seth, at the end, we again find ourselves in somewhat of a bit of a mystery of what GovCon should do. But, what's your advice to our listeners as far as, based on these rules, as far as, what are the active steps? What are the things you need to be paying attention to?
I think I think that the easiest and most cost-effective step is really to do an efficient self-audit. Why not just lift up the hood, just check on the carburetors and see how are you doing with regard to the most current iteration of your hiring practices, your onboarding policies, obviously your handbooks. If you do that process and if you review it with your legal counsel, alluding to something that Declan noted a few minutes ago, that would be subject to attorney-client privilege, so that if you have observations and opinions that are reflected in those documents, those observations and opinions are privileged, and then you can go ahead and you can create and modify this. And announcer prevention is definitely the way to go here. So be proactive, be self-reflective. It's a very cost-effective way to just take a look at the problem, and also even an hour's worth of training with your managers is something, as long as people are aware of it and you can demonstrate that, I think that you're going to definitely get extra points with the Justice Department.
I agree, yep.
How soon will we, I'm not sure if you guys have any clients as far as these letters going out, and will there be a sense on the street of people starting to receive these? Any
I
indications?
have not gotten an indication from any clients that they've gotten one of those CIDs. They have had to sign those certifications for pay applications that basically say we don't engage in any illegal DEI, and that alone sets them up for a False Claims Act potential claim themselves. So that's also, so they're coming at it. This administration is coming at it many different ways. They're encouraging employees to file qui tam actions, which are actions like, basically, we're telling on our company that they are doing this stuff, and it's financially lucrative for a potential employee if they win. So they have different avenues. They're sort of circling the wagons around these companies, and that's why I think it's not a fad. It's very, very, very potent concern that companies should have.
Yeah, the other thing that I would mention is if you kind of zoom out from a procurement perspective, use it as a feather in your cap.
Yeah, good point.
And just be able to demonstrate that as a responsible contractor, which is something that you need to be able to demonstrate to have baseline qualifications under the FAR to be able to submit for government contracts, that you have the appropriate and necessary internal controls and procedures to be able to provide that representation, which again could be a False Claims Act issue as far as an overexcited federal official is concerned. But if you do this, give yourself a gold star for that, and make sure that you put that out there so that the contracting officer or the relevant review authority at the agency is aware of the fact that you're doing this. It's obviously going to be much more to your credit to be able to be proactive, look under the hood, report that as being a responsible contractor. If you do that versus being reactive, it really can make a world of difference.
Yep, totally makes sense. Yep.
Well, I hope after this 25 minutes that our listeners are like, yeah, I'm glad I stayed on. Yes, there was more to learn. Yes, there is more news. Hopefully, as we have been our practice the past few months, we have not picked a topic for next month. And that's kind of
It's already going to be DEI.
It's served us well.
What's that?
If it's DEI, there may be a new host. I may not be in this chair. Can we come up with something lighter next month? I feel like, I feel bad for our listeners.
Like
we need to bring something that maybe after the half hour, our listeners aren't like, oh.
Well, we'll be knee deep into NFL season, so we can talk.
Okay. So
we
maybe
can talk
we can soften
Commanders on a winning streak.
Oh, God.
The Eagles maybe not living up to expectations.
But we'll see if we can
would.
find something not related to DEI next month. Something maybe a little lighter. That I hope we didn't. Ruin people's afternoons, or just like one more thing I know that you have to kind of deal with in the ever-changing world of being an HR professional in the GovCon
Look at it on the
space.
bright side. It may be a while now that we don't have to talk about DEI. We don't have to talk about DOJ. We don't have to talk about all these things. And now, with the new fiscal year coming around, there are reasons to really consider the glass half full right now.
Yeah, I mean, two developments. I mean, we've got 2 more minutes left, so two other developments. The OFCCP, remember, up until January, federal contractors have long had to file these affirmative action plans, basically saying what affirmative steps have they taken to hire minorities, and they were kind of onerous requirements. Those have now gone away, and the OFCCP has now announced that they've disbanded all investigations, all active investigations, and from now on going forward, the only affirmative action will relate to the hiring of veterans and the disabled. So that's
our
one.
good news for today.
Yeah,
if you weren't aware of that already, thank you for lighting it and bringing us some good news.
But
for
wait, there's
today.
more, because the National Labor Relations Board, and we actually spent a couple of our roundtables, at least a couple of them, talking about the National Labor Relations Board, the NLRB, because they were incredibly active during the Biden administration. They were the ones, we did one of these on how primes and subs were going to be considered joint employers under the National Labor Relations Board. Well, guess what? The NLRB may very well be going away. There was a Fifth Circuit Court of Appeals, a very powerful federal appellate court, that basically just ruled that the NLRB, because of its structure, and we would need 2 hours to get into why, but because of its structure, it may very well be an unconstitutional, like, sort of executive function.
Wow.
And so therefore, and the NLRB is the one that also handles all union activity, unfair labor practices. So people out there with with Service Contract Act contracts.
interesting. Yeah.
A lot of times along the lines of that, you have unions.
A lot of union in there,
That if you have a complaint, I don't know where you go if the NLRB is gone.
Can you imagine the conservative justices in the Supreme Court building just licking their chops, hoping that they get an application for review on that one? They would gobble that up for lunch. They would love that case.
So you think that they would disband the NLRB?
Oh, in a heartbeat.
Yeah, because they think that it's like it's usurping congressional power. It is basically putting too much power as a separation of powers into the executive branch.
It's a regulatory overreach, especially when you look at the recent Supreme Court decision that blows up Chevron and all of that progeny. Yeah, I think.
Yeah.
If that happens, I mean, you've already got a big deal going there. So I wasn't even aware. I knew that case was pending, but I didn't know that was the ruling.
That's a big one. That's a big one.
That sounds like a Roundup podcast topic of the future.
Yes. We will put our hats on and figure something out good.
Yeah.
All right. Well, everyone, thank you so much for joining us again. We hope you found great value with our experts here, Seth and Declan, today. Enjoy the rest of your summer. We will be back in September on our normal Thursday time. That will be September the 18th. Topic to be determined based on the landscape ahead of us. So we'll keep an eye on it and make sure we're bringing you the latest and the greatest when we see you next month. Thanks again, and take care.